And I went in and cut the live back on. It's doing the same. It's saying media is now streaming live. Same thing it said before. I don't know why it wouldn't have been. Hold on a second.
Sure.
All right, you gotta hold on for a second. You gotta call IT for some reason. It's telling me I'm streaming, but it's not streaming. So we gotta take a brief adjournment.
Judge, does that mean that we're recording though, right? So we don't have to like start
Yeah,
over. Okay.
we're recording, but we're not streaming live on YouTube, and we have to be available to the general public.
Sure.
So, yeah, so without it live streaming, I'm not supposed to proceed. But it's saying on my computer that it's live on YouTube. But they're pulling it up and they don't see it. It's not showing, so they got to call IT or either have them explain to us what's going on. Come up here and fix it. Tell them I'm in the middle of a hearing. I am. I'm trying to get somebody right now. All right, hold on.
So they don't have YouTube problems. YouTube problems. Who's having YouTube problems? The court. Oh, the court.
All right, let's continue this. I don't know what they're talking about. It's showing up on mine, so we're gonna keep on going. All right, let's go.
Do we have to recall the case, Judge?
Oh, I have a brief question. On the, can you put up the, advice of rights, 9:56, is that AM or PM?
It would be AM. It's 0956 hours. Military
Oh,
time.
okay. Okay. Thank you.
Yes, Your Honor.
Judge, do you see it now? Are you able to see it?
Yes.
Okay. Okay. Officer Daniscu, I think we left off at okay, yeah. Did the defendant ever appear to be under the influence of alcohol when you were either giving him, well, let me just ask you, let me strike that. Did the defendant appear to be under the influence of alcohol at any period on July 4th, 2020?
Not in my possession, no.
Okay. Did he appear to be under the influence of any kind of drugs?
No.
Did he appear to be under the influence of any kind of medication?
No.
Did the defendant ever tell you that he was on medication?
Not that I recall, no.
Okay. Did you ever see any visible injuries on the defendant at any time during July 4th?
No.
Okay. Was he ever refused food?
I don't know if he ever asked for food.
Okay. Was he ever refused water if he asked for it?
No.
Okay. And after you went through the constitutional rights with the defendant, he read them and then he signed the form. Did he agree to speak with you?
Yes.
Okay. And did he?
Yes.
Okay. And officer, I'm now showing you a 3-page document that has been marked as People's Exhibit 2. I want you to take a look at it. It should be a shared screen. So this is page 1, page 2, and page 3. Do you recognize this document?
Yes. This is the document I would have used for the interrogation. It's the questions I asked and his answers.
Okay. And when you say his answers, are you talking about Michael Drew?
Yes, Michael Drew's answers.
Okay. So is this a fair and accurate?
Hold on a second. Hold on, Mr. Drew. Mr. Drew, I need you to put your camera on. I need to know that he's present. Okay, I want to make sure you're present. Okay.
Okay, and Officer Daniscu, is this a fair and accurate copy of the written statement the defendant provided you on July 4th, 2020, after being advised of his Miranda rights?
Yes.
Okay, at this time, the people would move for the admission of People's Exhibit 2 as People's 2.
Any objection?
May I have order the witness?
Sure.
Officer, on the Miranda rights, you didn't have the defendant read the statements out loud, correct?
No, I did not.
And when he said he had a GED, did he tell you he went to GED classes, or he didn't tell you he graduated and actually received the GED? Isn't that correct?
He said he had a GED.
Okay. Did you ask him, did he have a problem reading?
I don't think I asked him if he had a problem reading, no.
On your Miranda rights form, the second check, the 3 check marks, place those 3 check marks there.
What check marks?
On this, Ms. McCray, can you place the certificate of notification back on the screen?
Yeah, I just did.
Okay.
Oh.
See the 3 check marks?
Look like my check marks.
Okay. The second one where it says, can you read the first sentence of the second box?
Suspect is, no, I can't, it's too faded, I'm sorry.
Does it say suspect is illiterate?
It looks that way, yeah.
Okay, why did you check the box that says suspect is illiterate?
I don't know if it, I mean, he was definitely literate of his. I mean, he definitely understood what what I asked him. He verbally stated, "I understand my rights," that I read to him.
Okay. Now this document that you had, you prepared it accurately, correct?
Correct. I mean, if it
And
might have
you
made a
wouldn't have
mistake,
checked. He never read one sentence to you at all. Isn't that correct?
not out loud, no.
Okay. And when you question him, it was fresher in your mind on this particular day back in July the 4th of last year than it is today, correct?
Correct.
And you're not denying the fact that you checked the box that the suspect is illiterate, correct?
That box could have been checked on accident. I mean, or it could have been a mistake.
But you're guessing, correct?
I'm not sure why I would have checked that box.
Okay. And did you ask the defendant when was the last time he took any medication?
No.
You didn't ask the defendant whether he was on medication, correct?
I did not ask him if he was on medication.
Your Honor, I have no, I'll save everything else for cross-examination.
Well, let me ask a quick question. You checked that he's illiterate, but then you also checked that he reads and writes, which seem to be opposite of one another.
It's probably a mistake, Your Honor. I don't recall checking the boxes. I mean, obviously I did. I just don't recall why I checked all 3 boxes.
Okay, well, let me ask you this. Did you ask him if he read and write?
I don't know if I those exact words, but I believe that he could read and write because of his GED.
Okay. Did you read the rights to him, or did he read them to you?
He did not read them out loud to me. I did hand him that sheet of paper. I asked him if he wanted to look them over. He looked them over. I asked him to sign them if he understood them. So not sign, but by initialing to me, he stated that he understood his rights by initialing them.
Okay. So you asked him if he understood his rights for him to initial.
Yep.
All right. Did he tell you he didn't understand?
He did not say he did not understand.
All right. All right. Go ahead, Ms. McCray. That being the case, the court will indicate at this time that the statement was voluntarily given.
Okay, so permission to publish?
Yes.
Okay. So Officer Danescu, according to, and I'm turning now to People's Exhibit 2, page 1, it's a 3-page exhibit, or I should say People's 2, because it's now been entered into evidence. So People's 2, page 1. On this page, does there indicate a time when the questioning began?
Yes. Towards the top. It
Okay.
says start time 10:05 hours.
Okay. So, so you began questioning him at 10:05. Okay. What time did it end?
6 hours.
I'm sorry, you kind of came in and out.
10:26 hours.
Okay. So we're talking about a 21-minute period of questioning, right?
Correct.
Okay. And this was this inside his house, right?
Yes, inside his house, inside the orange bedroom that he stated was
Okay.
his.
And this is during the day? Okay.
Yes, 10 o'clock.
During this 21-minute period, when you're having this discussion with Mr. Drew, was he ever forthcoming with any kind of information?
Yes. At one point I asked him, it's not on the document you're showing now. I asked him about some.
Uh-oh.
No, not that one.
And you're Witness, you're gonna have to restate that because the court couldn't understand it.
I asked him about a brown sandwich, brown substance, and it was lactose or something. I said, but did you have knowledge? I asked him if he had knowledge of the brown substance in the sandwich bag found in your house. He said, yes. I put it up there out of the reach of the kids, along with the gun that I found cleaning a house. It had.
Judge, I'm gonna make an objection to that. Excuse me. I'm gonna make an objection to.
I can't even hear the answer. So I mean, I gotta go back. I didn't understand what was said anyway.
And what I just would like to inform the court of is we're here based upon a violation of Walker. What the prosecutor is asking is totally irrelevant to this hearing.
I don't think it is, because I'm asking about whether part of the factors of voluntariness are prolonged and repeated questioning. If the defendant was forthcoming with his own information, that certainly doesn't weigh in favor of the police doing repeated or prolonged questioning.
What was your question, Ms. McRae?
I said, during this 21-minute period, was the defendant ever forthcoming with information?
Well, he gave a statement, so we already know he was forthcoming with information.
Right. I guess I just meant, Your Honor, if he provided information that the officer didn't ask of him.
Oh.
Are you stating that? Are you stating that?
So go ahead, Mr. Upshaw.
I think what she's saying is that if the defendant was answering questions and the officer wasn't writing down those answers in his interrogation form.
I don't think that's what she's saying.
No.
Ms. McRae, just be a little clear with your question.
Sure, Judge. Officer Danescu, was there ever a point during this 21-minute period where the defendant provided you information you didn't ask about?
Yes.
Okay. Now, during this 21-minute period, did the defendant ever tell you he didn't want to speak to you?
No.
Did he ever tell you to stop the questioning?
No.
Did he ever ask for an attorney?
No.
Okay. And last, I want to talk about kind of the timeline of events from the traffic stop to the questioning, so we can get really clear on the timeline. So, you said there was a traffic stop at the beginning of the day, right?
Correct.
Okay. Now, earlier I had asked you if you remembered the specific time, right?
Yes, I was unsure at the time.
Okay. Would there be something that would refresh your recollection as to the time that traffic stop began?
Our crew does provide a main report that gives a generalized summary of everything. The time of the traffic stop would be on that.
Okay. What about an investigator's report?
That would also be on that, yes.
Okay. Did you write an investigator's report pursuant to your investigation in this case?
I don't know if I wrote it or if someone else wrote it. I would have to look at the investigator's report.
Okay. I'm going to show you on my shared screen. Oh, this is up here. A copy of, well, I'm going to just say a one-page document. And you tell me if you recognize this document at all.
Yeah, this would be
part of the investigator's report. Say that one more time. You came a little bit in and out. Officer Danescu?
Yeah, so I did investigator's report.
Okay. And
I'm sorry, I didn't hear you, Officer Danescu. What did you say?
I did prepare that investigator's report, Your Honor.
Oh, okay. Okay, go ahead.
Okay. Take a look at this investigator's report you prepared and look up at me and tell me if it refreshes your recollection as to the time the traffic stop began.
You know, I don't see the time on there for the actual traffic stop.
Okay, so this document doesn't refresh your recollection as to the time of the traffic stop?
No, it is not.
Okay.
Let me ask you, you have the officer's police report?
Um,
Do you have the police report as to when the traffic stop was made?
well,
John,
Judge,
I would just,
if I
I
could,
would just
go ahead.
make a objection to those asked and answered. The officer was asked, how long did it take to get to from the stop to the house? And he said, no, approximately a half an hour.
Okay, that's
No,
fine.
that's not what he said. He said much less than a half an hour,
Yes.
much less. But when she asked him what time was the stop, he told her he did not know. So I think she is attempting to refresh his recollection. But that document that she has is not doing it. But that also is not a police report, it's an investigator's report. So I'm asking if there's a police report that would refresh his recollection as to when the traffic stop was.
Judge, so yes, there might be. There is a time on here. If I can use this to impeach the witness, I think I can point out where it says it.
Why don't you just point it out and ask him to draw his attention to it and have him look at it?
Sure,
You don't
Judge.
have to impeach him, he just doesn't see it.
Okay. Officer Danescu, can you, I'm going to direct your attention, I don't know if you can see my mouse, to the narrative portion of the investigator's report, the last sentence, where it says, it begins with.
Don't read it, just point it out, let the witness read it for himself, and then ask him if that refreshes his recollection as to what time the stop was.
Yes, Judge. Okay, so drawing your attention to that location in the investigator's report, does that refresh your recollection as to the time of the traffic stop?
So the investigator's report says that crew conducted the search warrant around 0840 hours. So the stop had to have been at least in between 8 o'clock and 8:40 at that point.
So you still don't know specifically then?
I don't know, Your Honor, I don't know the specific time.
Okay, but it was in the morning,
It was in the morning, Your Honor.
around 8 something.
Correct.
All right, let's move on from that.
Okay, thank you, Judge. And just to be clear, your interrogation of the defendant took place did it take place at a different location?
From the traffic stop?
Yes.
Yes, it did.
Okay. And do you know about how long in time, approximately, the time was between the traffic stop and starting the interrogation on the defendant?
I believe the start of my interrogation was around 10. I'd have to look at the sheet before that you showed me earlier, but I know it was 10 o'clock. And then the traffic stop was before 8:40.
Okay. So is it fair to say that it's more than an hour of time had lapsed?
Yes.
Okay. And finally, I want to ask you, what was your role or duty on this case?
So I was assigned to the clearing or entry team. I was also assigned to the rifle position. So I was the initial entry team. We cleared the location. After that, we all take turns, and depending on what you do, we all have different roles and just fill in. There's no set position afterwards.
Sure. So I guess my question is more of, did you perform any background research on the defendant?
Before or after?
At any point in time?
Judge, that's not relevant here.
Judge, it is relevant.
What's irrelevant?
Part of one of the prongs for voluntariness of a statement is the experience the defendant has had with law enforcement.
Yeah, Ms. McCray, I can see what the experience he's had.
Okay.
got the information, so.
Okay, I just wanted to make it clear on the record, but Your Honor is saying it's clear to you from the information, then I don't have to go into it.
All righty.
I have no further questions.
Ben,
Yes, Ms. McCray, you can remove your exhibit.
Sure. Stop.
Okay. Officer, you were present when Mr. Drew's vehicle was stopped, correct?
After it was stopped, yes.
Okay. And what was the purpose of the vehicle being stopped?
Judge, I'm going to object to relevance.
It's totally irrelevant. You're talking about voluntary.
We already determined, and I already stipulated that the first statement is not admissible. We're only here to determine the voluntariness of the statement provided at the home.
Okay, first of all, I would accept the fact that the first statement was involuntary and inadmissible. But Your Honor, it's still relevant to show the continuation.
go ahead, Mr. Upshaw.
You were present when the defendant's vehicle was stopped, correct?
After it was stopped, correct.
Okay. And you stopped that vehicle pursuant to a search warrant, correct?
I did not stop that vehicle, no, sir.
Okay. On your direct examination, you stated the vehicle was searched pursuant to a search warrant, correct?
I don't
Correct.
think that's was it the vehicle search?
Yeah, it
Well,
was.
Well, hold
I don't know
on,
if the vehicle was.
hold on. Let the witness answer the question. Go ahead.
On direct
I don't-
examination, when a prosecutor asked you a question, you said the vehicle was stopped with Mr. Drew in it because you were going to execute a search warrant. Is that correct?
Correct.
You did not have an arrest warrant for Mr. Drew. Isn't that correct?
Mr. Drew's name was the target seller for that location along with that vehicle was in
My
the search
question
warrant.
is, you did not have an arrest warrant for Mr. Drew, correct?
I did not have an arrest warrant, no.
You're not aware of an arrest warrant at that time for Mr. Drew. Isn't that correct?
That is correct.
And at the time that Mr. Drew's car was stopped, there was no warrant for his arrest of any kind, correct?
I'm unaware if he had any outstanding warrants at the time.
Now, when Mr. Drew's vehicle was stopped, you stated you were in a raid van, correct?
Correct.
And there was a patrol car that stopped him, correct?
Correct.
So there's at least, what, 6 or 7 officers there when Mr. Drew's vehicle was stopped?
I'm not sure the exact amount, but it's fair to say there was more than 5.
Okay. And when Mr. Drew's vehicle was stopped, multiple officers stood there as he was removed from his vehicle. Isn't that correct?
There would be multiple officers on the scene for safety.
Yes, some in raid gear and some in uniforms, correct?
Correct.
He was not free to leave, correct?
Correct.
He was not free to refuse to get into the patrol car, correct? He was taken to another location, correct?
Correct.
He was handcuffed.
Correct.
And you were with Mr. Drew or in his proximity from the time that he stopped. And did you overhear you were not disputing the fact that he was questioned and talked to when he was immediately removed from the car, correct?
I have no idea what other officers said to him, sir.
Okay, but you were present and you didn't see all other officers talking to him?
I was busy doing my part of the job. That's, security around, keeping the outside perimeter. So I have no idea what the other officers were doing.
Okay. When you took Mr. Drew to the target location, you placed him in a bedroom and he was by himself. Isn't that correct? Besides officers.
Correct.
And Mr. Drew were you aware of the fact that Mr. Drew had already made statements about the house prior to entering the home?
I was unaware of any statements.
Okay, so you didn't talk with no other officers about Mr. Drew's arrest and statements?
I was aware that Mr. Drew gave the key to the front door.
Who asked him for the key?
I believe it
Judge,
was
he
my
already
supervisor.
testified he didn't hear any of the officers asking questions.
With all due respect, I have a
Wait.
right to ask questions too.
Right,
Yes.
but he already answered your
Ms.
question.
McCray, Ms. McCray, let the witness answer. It's not rules of evidence don't apply. Let him go ahead and answer.
I
He's
believe it
already
would have been.
testified. Go ahead.
I believe it would have been my supervisor, Sergeant Banks.
Okay, were items removed from his pockets?
I have no idea, sir.
Put it this way, when the prosecutor asked you, was he threatened in any way? Do you recall that question?
Correct.
If Mr. Drew would have took off running, what would you have done?
Not objection, Mr. Upshaw.
Okay,
You know that is speculative.
all right, I'll
So
rephrase.
we're not asking about what would he have done. We're asking what happened. So let's not waste the court's time with that. Move on.
In closing, officer,
Sir?
was there any time between the time that Mr. Drew was removed from his vehicle to the time you interrogated him? Was he free to go?
No.
Was there any time from the time he was removed from his vehicle to the time you interrogated him, had you left his presence,
I'm sorry. When I left his
Okay.
presence?
where you were no longer near and same proximity as Mr. Drew?
So Mr. Drew was put in the scout car. I was in the raid van. Mr. Drew was left in the scout car. I conducted the raid.
Okay,
So-
so Mr. Drew was in the scout car for a second outside of the house while you went inside of the house and conducted the raid, correct?
Well, I conducted the raid. Yes, correct.
Right, and then you brought Mr. Drew inside of the home as soon as you cleared the house, correct?
Not as soon, but he was put on the porch and I got him from the porch and put him inside to conduct the interrogation.
Okay. Who had Mr. Drew going to the back? Excuse me. Exact words. When Mr. Drew was outside in the scout car, he was handcuffed, correct?
I'm not sure if he was handcuffed outside of the scout car.
Okay, but he was under arrest at that time, correct?
He was not under arrest at that time, no.
Okay, when did he get placed under arrest?
After the interrogation,
Okay, so from the time that he was removed from the car, taken to the house, he was not under arrest?
No, he was being detained for investigation.
Nothing further, Your Honor.
All right, anything further from the people?
No, Judge.
All righty. There was a couple motions filed in this case. Originally, the motion had filed by the defense was to suppress the weapon. However, as we've indicated in black and white, there was a search warrant for the home, which was located at 19250 Klinger in the city of Detroit, state of Michigan, county of Wayne, in which it authorized officers to search the home, to curdle it, and I believe that Mr. Michael Drew, well, you know, let's also state this too before. Mr. Drew put his name on the record, and technically, the people really should have had the officer identify whether this is Mr. Drew, and that was not done, which was a critical mistake for the people. However, if the court dismisses this based on that, only thing that's going to happen is people going to refile it, and we'll be right back here, which is not in the interest of judicial economy, because Mr. Drew has already indicated who he was, but the prosecutor should have asked that. So now I'm going to ask, officer, do you recognize anybody that's on this call?
Yes, Your Honor. It's got the name underneath his face, Michael Drew Sr.
All right. You know, we on Zoom, Mr. Drew has already identified himself, but, and again, I am acknowledging, and I am not being the prosecutor here, but I'm acknowledging that, you know, if I indicate there's no identification, all they're going to do is refile it, and then we'll be right back here again. So, you know, that's the first thing that should have been done, is that the officer should have identified that the person that he's referring to as Michael Drew is the Michael Drew that's on this call. Now, with that out the way, let's go to the motions. There was a motion that was submitted by defense to suppress the weapon. However, there was a search warrant for the home, and the weapon was found at the home, and they had a valid search warrant for that. And Mr. Drew actually was named in that search warrant. So then there was another, once we had oral argument, it became apparent to the court that the defense was not requesting to suppress the weapon, but the statements made by Mr. Drew. Statements that there was a gun in the house, and Mr. Drew, being a prior felon, and cannot be in a house with a weapon. There was some argument as to when the statements were made and whether Mr. Drew was in custody and should he have been questioned prior to giving Miranda. When we were in court previously, the defense had indicated to the court Mr. Drew was not given his Miranda warnings when he was detained at the vehicle. Ms. McCray indicated that he wasn't detained, basically. But after reviewing the video, Ms. McCray then filed a new motion indicating she watched the video. Mr. Drew was in handcuffs, thus he was detained, and so he should not have been questioned at the scene. And the court does agree with that. He should not have been questioned at the scene because he was detained, and there shouldn't have been any questions asked of him at that time anyway. They were taking him to the house. He voluntarily gave them the keys based on my understanding of not only the testimony here today, but what was in the motion. And he gave them the keys in order for them not to break the door down. And it was Mr. Drew's home, or at least the home where he lived. So the issue has become whether the statements made once he got to the house which were made after he was Mirandized, are admissible at trial. So in order to make this decision, the court has gone to Oregon v. Elstad, ELSTAD, 470 U.S. 298. It's a 1985 U.S. Supreme Court case, which talks about statements that were previously made without being Mirandized, and then a statement that's made after. It is not completely, the analysis does not stop with the fact that someone gave a statement previously simply because there was a failure to administer the Miranda warnings. In that particular case, the Miranda warnings will be suppressed if someone should not have been questioned because they were detained or arrested and did not feel that they were free to leave and may have been under some kind of pressure, which would have been the case here. But if a person then subsequently gives a voluntary statement after that initial instance where they gave a statement without the warning, that statement can be used if, based on us going through an analysis, the court going through an analysis as to determine whether that statement was voluntary. And there are a couple of factors that the court has to look at. Number one, the age of the accused. In this particular case, Mr. Drew, based on the exhibit that was admitted by the people into the record, Mr. Drew's birthday is June 14, 1963, which makes him 58. So we're not talking about a young person. The other thing is the lack of education or intelligence. So there's an issue there. It has come up. There was testimony today by Officer Dinescu, who's been on the force for 7 years, major violations task force, who was at the stop of Mr. Drew, but not involved in the stop of Mr. Drew, was present, but did not speak to Mr. Drew, or did not handcuff Mr. Drew, wasn't sure if Mr. Drew was actually handcuffed, thinks he was, but didn't participate in that. Has testified that he didn't speak to Mr. Drew at all at the traffic stop, doesn't know who spoke to Mr. Drew or what any conversations were about. He did indicate he received information from his supervisor that there was a key to get into the house so that they didn't have to force entry. And I'm assuming that the supervisor told Mr. Officer Dinesco that because he's part of the raid team that's going in the house, and if they don't have a key, they knock the door in. So he received that key. Officer Dinesco said that he doesn't remember around what time the stop was. I believe he said the search warrant was signed, I don't think between 8 or 8:40 or something like that, a.m. The stop would have been sometime after that. There wasn't anything to refresh his recollection exactly when the stop was made, but it was in the morning hours on July 4th, I believe that is, 2020. He indicated when the people asked him how long they were at the stop, he said from the end of the stop to the time they got to the house, much less than 30 minutes. They didn't indicate how far it takes to drive from the location where the defendant was stopped to the house, but he said it wasn't that far. Then Officer Dinesco testified that once they arrived at the location, he's in the raid van, Mr. Drew is in the scout car, so he's not the person with Mr. Drew. They go into the house, they clear the house, him being Officer Dinesco and some other people. And that's to find out if there's any other individuals there to bring them to a central location, which they did. Then they go about searching the home. And he then indicated He then has a conversation, or he talks to Mr. Drew. Now, that's where the rest of the factors come in. He gives Mr. Drew the advice of rights form. Is that what it's called? I want to make sure this is correct. Advice of rights form, correct?
Correct.
All right. He gives him that advice of rights form. He indicates, Officer Dinesco, that there was at this point, Mr. Drew is not in the scout car anymore. He's been removed to his own residence. He's in his own bedroom, which he says is orange. And I believe he says it's just him and Mr. Mr. Drew, Officer Dinesco. And he asked Mr. Drew if he wants to speak, and Mr. Drew says he does. So he goes through the advice of rights. He says he reads the advice of rights to Mr. Dinesco, or hands him the form, has him read it over, him being Mr. Drew. But he asks him, does he understand those rights? And Mr. Drew indicates that he does. And he initials next to each one of them. He asked Mr. Drew what his educational level is, and Mr. Drew told him he had a GED. Defense crossed and asked, did Mr. Drew tell you he didn't finish the GED? And Officer Dinesco said, no, he told me he had a GED. It was pointed out that all of the boxes were checked on this form. Box saying he was illiterate, but then there's also a box saying he could read and write. He was then asked, the witness was asked whether, while the boxes were checked, he said he might have checked them by mistake, but he did ask Mr. Drew if he understood. Mr. Drew said he did. The prosecutor asked Officer Dinesco if the witness was deprived of food or water. The witness indicates no, but he doesn't also remember Mr. Drew asking for any of those things. He was asked whether he believed the defendant, was under the influence of alcohol, drugs, or medications. He said no. However, on cross, he was asked whether he did ask the defendant if he was taking any medications. He said he didn't, but there's no indication that he took any, or that it didn't appear to him that he had taken any. There was questions asked about whether Mr. Drew, any threats were made to him, any promises made to him. Was there any physical contact, as in he was assaulted in any way? Those answers were all no. So as far as lack of education or intelligence level, the court notes that on the advice of rights, it says that he has a GED. Both boxes are checked, illiterate as well as can read or write. But the testimony is that Mr. Drew understood because he initialed, and his initials are on the form. On that form, I can't remember, and I didn't write this down. Is Mr. Drew's signature also on the form?
Yes, I can bring it up, Judge.
Please do, because I want to make sure that the record is not based on what the people are saying, but what the court has observed.
Sure, Judge.
Your Honor.
Yes.
He does sign that advice of rights form with the advice of rights. He also signs each
Well, I'm
page.
not asking any more questions, officer. We're done.
Oh, I need to share.
Let me see the advice of rights form.
Just 1 second, Judge.
All right. So the court notes on People's Exhibit 1 that there was testimony that the defendant initialed next to each of the rights that he understood. There's also his signature at 9:56 hours, which is AM military time. The court also noted that this interview ended at 9. The advice of rights was given at 9:56. The questioning began at 10:05 and ended at 10:26. And that's on the,
I can go down. I think it's
the question, what's the time, I want to make sure I have the right
So Judge,
questioning form, I guess I'll call it. It doesn't have a, let me see the top of it. Does it have a title on the top of this questioning form?
that is,
Well, I'll call it People's Exhibit number 2, which was the questioning form, which indicated that Mr. Drew's questioning began at 10:05 and ended at 10:21. So, with respect to the lack of education or intelligence level, the court does not find that he did not understand what was going on. He indicated to the officer he had a GED, and he initialed next to each of the questions indicating he understood, and he also signed it. He is 58 years old. Previous experience with the police is the next element that I must look at with respect to these factors. And the court notes, based on the information, that Mr. Drew is a habitual fourth offense. That being the case, the court notes that he has had numerous contacts with the police previously. Repeated and prolonged nature of the questioning. Well, we determined that the questioning lasted for approximately 21 minutes. So the court does not find that the questioning was prolonged. The lack of any advice to the accused of his constitutional rights. Well, we know that he was given that because he signed it in the initiative. Was the accused injured in any way? We don't have any evidence of that on this record, or that he was intoxicated or drugged, or there was anything wrong with his health, or that he was deprived of food or sleep or medical attention. We don't have any evidence that he was physically abused or threatened. And all of these factors come out of People versus Akins 259, Mish App 545 at 564, 675 Northwest 2nd, 863, 2003, quoting People versus Cipriano 431 Mish 315, 334, 425 Northwest 2nd, 781, 1988. The last analysis that the court will go through is whether the questioning which took place the first time, was there some kind of break between, because that's another aspect. If there was no break, in that the questioning took place at the same location by the same person within a few minutes, and so it doesn't appear that the defendant would have had an opportunity to then make a decision to make a voluntary statement, then the court might have to make a different decision. In this particular case, he's now in his home as opposed to being at the car where he was before. He's being questioned by somebody who did not question him before, because this officer has indicated he wasn't involved in the stop, nor was he aware of any questions asked of Mr. Drew, or that Mr. Drew had given a statement before. He, per the officer, was only told that there were keys to allow him to get in. He's a part of the raid team, and that's what they use. It was a few minutes later. They're at a different location, different person. Questioning was not long, and that is the end of my analysis.
But Your Honor,
That being the case,
excuse me, Your Honor.
yes, yes.
Are we going to be able to be allowed to make a argument before you make your decision?
Well, I mean, you guys can make an argument if you like, but you have briefs that both of you have actually submitted 2 briefs apiece, plus an evidentiary hearing. But if you like to make more of an argument, go ahead.
Thank you, Judge. The key part that I was listening to that's missing in this particular part is the cases that I cited in the brief. They said the prosecutor has, or the people have to have the burden of removing not the fact that he was just re-Mirandized, but this mental taint and the coerciveness had been removed. In this particular case, Judge, I would ask the court to pay attention to what all the case law said about removing the coercive nature. His original, and they distinguish between a coercive arrest and a voluntary, where the young boy volunteered to walk, open up the door and talk to the police, and everything was voluntary. The court said if it's voluntary, then that's totally different. Now, in Mr. Drew's case, he was pulled over, stopped by multiple officers with a raid van behind him and a patrol car. So they got these black uniforms, a bunch of guns, and they snatching from the vehicle. First of all, there was, like I said, just short, there was no arrest warrant for Mr. Drew. So he was unlawfully arrested from the beginning. Making it brief, he was questioned in a coercive nature. He snatched out of the car. People have guns. They take him against his will 5 minutes away to this, 10 minutes away, whatever time you says, to this location against his will. There's no, the coercion and the coercive tactics of his arrest was not removed. Now they place him in the car. He's handcuffed. He has no time to mentally think of something else, to talk with someone else, to think. They take him in the house and he watched the house being raided with a bunch of officers. They come out, they take him without consent again into the location, place him in a room and continue to question him. Now, even though Officer Danasco wants to say he wasn't the officer at the scene, at the original scene that questioned him, every case law I've ever seen, they're working in unity. He was there, he was present, he was armed, he was part of he followed Mr. Drew. Just because he didn't ask the question, Judge, that's not it. It's the same group of officers. Now, when this same group of officers forcefully, and what I state is unlawfully, remove him from his car and take him to the scene without an arrest warrant, they take him into the room and continue to question him. Even though Officer Danasco wants to say that I don't remember or I didn't talk to him when he was on the street, he the one took him out of the car. He was part of that group. Judge, with all respect, the Supreme Court and other courts has stated, it's not just the fact that he was moved across the street. The environment, the psychological effect upon him have to have changed, and the government has that duty before it can go forward, that they must show that that psychological effect on his mind have been removed. Nothing here shows a psychological effect. They didn't give him time. Okay, it was an hour later. People pull guns on you, snatch you out the car, drag you to another location. That psychological effect is here. They start questioning him without reading his Miranda rights to answer the question. That psychological effect is here and has not been removed. They drive him 5 or 10 minutes away against his will, still with guns, take him to the house. They don't ask him whether he wants to go into this house. They just takes him into this house, sits him in this room by himself, and begin to question him again. Within an hour or so, Judge, that psychological effect is not gone. Now, I hear Your Honor making preference, well, it's a change of place. No, it's not. It's not as if he was taken from his home on one day and the next day, like most cases say, some different officers that was not involved in that came and questioned him. This is all simultaneously, Judge. He didn't have any break by himself to think. He was constantly up under the guard and control of this crew. So, Judge, I ask you, before you make that decision, when you read the case law, it says the government must, not can or should, must and shall remove the psychological effect on the defendant's mind from the first confession. And Judge, and if you want to say because I made you confess on one side of the street, then I took you across the street, that's a different location. I'm quite sure the Supreme Court didn't mean that. And if they want to say, me and my buddy snatched you out the car, he questioned you on one side of the street, and I questioned you on the other side of the street, that's a break. No, Judge, they acted in unity. The whole unit was in unity. If they were being charged with a crime, they would charge all the officers with conspiracy because they're acting together. So, Judge, when you look at this short period of time, this short change of location from up the street to down the street, a few minutes away, Judge, there's no real change in location.
I want to make sure. Are you done,
From
Mr.
the
Upshaw?
car? Yes.
Oh, okay, I didn't want to cut you off.
But what I'm saying, Judge, this is against what the courts has ruled, because One side of the street to the next street is not a change of location. An hour difference from one crew member to the other person in the uniform who all are there together is not a change of supervisory or control. And then did you think, when does he have a time to clear his mind like the Supreme Court said he must have? When was it time to show that the taint from him being snatched out the car was removed? And I cannot say in any form of fashion.
Upshaw.
Yes.
Okay, Mr. Upshaw. First of all, I hear your argument, but you're adding a lot of things that I did not hear on this record. Number one, there was no testimony that he was arrested at the car. The testimony was that he was detained at the car. And not free to leave is not the same as the ability not to have to talk. If he's not free to leave, doesn't mean it's up to him whether he chooses to give a statement. Just because you're not free to leave doesn't force you to speak.
But Judge,
and in this particular, I'm not arguing with you. Okay? You talk about the coercive nature. I have read the case law. And again, we're not going from across the street. We drove in a vehicle in which there is time from a location to another location, in which it's not even clear that he was even still handcuffed at the time he was in the house, because I don't have that on the record, and I have to make the decision by that. And we also are not talking about an individual that's 17 that has had no experience with the police. So I'm sorry, Mr. Upshaw, but I am not persuaded that Mr. Drew was not aware that he did not have to speak to the police. I'm not persuaded by that. So he was not arrested at the location. You keep saying he was arrested. He was detained and he went to his home. They took him to his home. Yes. Against his will? Yes. But he's not arrested yet. He is detained. And maybe, maybe if nothing was found in the house, maybe he wouldn't have been arrested. I don't know. All I can go by is at this point, he is detained. And no, he's not free to leave. That's what detained means. It doesn't mean arrested. And he's not arrested until he gives his statement. And there would have been a gun found because there was a search warrant. So that would have been found anyway. In a house where he was living, where he was not supposed to have a gun. So I have gone through all the factors. It is more than just the change of venue. It's more than just who spoke to him. And I agree with all of that. It's the coercive nature of the whole situation. But I do not believe that Mr. Drew, being 58 years old and having the experience he's had with the police, was also overwhelmed that he did not understand and gave up his right. He voluntarily gave up his right and gave a statement. And he did. And that's just what happened. Now, again, I've cited all the kind of case law, and I have read the case law. And defense is indicating that it believes I've read the case law inaccurately. And that's defense's position, and I respect it. And whatever the next step is, defense can do that. And if the Court of Appeals finds that I have ruled improperly, they will come back.
Your Honor, with all respect, I don't want to take up the question. I'll just make 2 points that I'm concerned about. First of all, you spoke about some evidence that you had not heard on the record. And I hate to interrupt this honorable court, but 2 things happened. One, when the prosecutor placed their first witness on the stand and I cross-examined him and I tried to speak, you went right into your decision without giving us an opportunity for Mr. Drew. Once the prosecutor didn't say they rested, they had said no more questions. you went into a conclusion without allowing us opportunity to call any witness and just started speaking.
No, Mr. Upshaw.
Right.
I asked, you said, I am done. That is what you said.
If
Now,
I said,
you did not say, court, I am planning, Mr. Drew is going to take the stand. I waited and you said, okay, I have nothing else. That was your word.
that was regarding Mr. Dinascu. And there's 2 points. One, because I'm not going to interrupt, but I was finished questioning this particular witness. The prosecutor's proper thing is at that point, they turn around and say, Judge, we rest. We have no further witnesses. Then I'm asked, do I have a witness? That didn't occur. The second part, Judge, that's why I'm sitting up here and I kept pushing the thing. I'm saying,
Wait. No. The prosecution.
All right, thank you, Your Honor.
No. The prosecution had already indicated they were resting. They don't have any other witnesses, so they are resting. She already had indicated that. It then became you. You asked your questions, and then you said you were done. Now, I assume when you said you were done, you were done. Now, don't say that the prosecution hasn't rested, because Ms. McCray has indicated she only had one witness. So she has to be rested. There's nobody else to call. She's not calling your person. So that being the case, Mr. Upshaw, if you would like to call Mr. Drew, and Mr. Drew would like to testify to something else that's contrary to what this officer said, then you're more than welcome to do that. I have heard defendants speak before, and that might change things. But when I began, and I think I took at least 10 minutes, at no point did you say, wait, Judge, I'm going to call my client. At no point did you do that, Mr. Upshaw. So if you would like to call your client, you can call your client.
Thank you, Your Honor. We'd like to call Mr. Drew.
Before, if we're going to reopen proofs, and after Michael Drew testifies, can I call the officer back to testify as to the identification?
I'll stipulate to us Mr. Drew, but you can call him if you wish.
All right. Well, if he's going to stipulate, there's no need of you calling him back.
Yeah, no.
But if Mr. Drew is going to testify, then Officer Dinesco will have to leave the call.
Okay, you can go, Officer Dinesco. Thank you. I'll be in touch.
I'm good to go.
Yes.
All right, thank you, Your Honor.
Now, the court has actually about 5 minutes before it has to leave.
Your Honor, so can we have another date? We should have another date if your court only have 5 minutes. Ask for a continuance.
Okay. What's the next date that we have that doesn't have a lot of matters on it? It's going to be in June.
June 16th's got 11 matters. June 18th has got 9 matters. June 25th has got 6 matters.
I don't want to go that far out. June 16th has 11.
Yes.
How many do we have on June 11th?
June 11th is 18.
All right, we're going to make this for, how many matters do we have on June the 2nd?
27.
Oh, no. What about on June 4th?
4th has got 19.
We're going to make this June 4th at 2 p.m.
Thank you.
Okay? We'll see everybody back on June 4th at 2 p.m.
And just to be clear, Judge, the people will not be bringing any witness at that
No.
point. Okay.
No, you do not need to bring your officer.
Okay.
I've heard everything from your officer. I don't
Okay.
think he has anything else to add. Okay,
Have a good day.
Thank you,
you
Judge.
too.